get started, everybody. It is my pleasure today to introduce you to Tueting. He is a partner at Patterson and Sheridan, which is a nationally recognized full-service intellectual property and technology law firm based in Texas. He earned his bachelor's degree from Baylor University in biology with a minor in chemistry before attending the University of Wyoming for his law degree. So I've had the pleasure of knowing Brooks for over a decade when he was going to law school. He is licensed to practice law in the state of Texas and with the United States Patent and Trademark Office. He has been with the firm since 2011, where he has excelled in IP law and litigation. Acting as in-house counsel for several clients, he ensures that their IP efforts align with their business goals, while also providing patent prep and prosecution services, litigation support, and portfolio analysis. And we are privileged at the University of Wyoming to have Brooks in charge of majority of our IP that runs through here for all of your innovations. So with that, welcome Brooks, and we look forward to your presentation.
Perfect. Thank you, Christina. I hope everybody can hear me. First off, I want to thank the School of Energy Resources for the invitation today to come and give a quick chat about intellectual property. Y'all are all brave souls for coming to listen to a lawyer drone on about lawyer things. So y'all, I probably think, get extra credit. Wanted to give you a little bit of background. I'm originally from the Mountain West, as Christine had mentioned. My background is in biology and chemistry, and then went on to law school. Decided to practice intellectual property. Intellectual property being a bit of a broader umbrella. Patent falls under intellectual property, copyright, trademark, trade secret. Those are all different legal constructs and concepts that qualify as intellectual property. And I'm sure that all of you have heard of those in some context in one way or another. Today, we're going to focus on the patent side of things. And I also wanted to take a quick show of hands, because I've got a portion at the end of the presentation today for kind of careers in IP law. I was asked to present on that as well. And so how many students do we have in the room, undergraduate or PhD or master's? Okay, so we have at least, maybe 10, 12? Okay, great. So we're going to start off. We've got kind of an agenda here today. I gave you a little bit of a background. We're going to start off with the patent side of intellectual property. And the reason this is so important in a university institutional setting is actions you take in the lab as a researcher during your collaboration with your colleagues, your third parties, whatever that may be. Those actions have the potential to impact the intellectual property that you may be developing. And so we want to start out, again, this is a little bit high level, so I apologize if this is a bit pedantic, but a patent is the right to exclude others from making, using, or offering for sale your invention. Now, I note that it's in the United States. You have to go get a patent in every single country that you want to protect your intellectual property in. There's no such thing as a global patent. We'll get into that a little bit later. But as we run through this, this is not a right to go do something. It's a right to exclude others. And that has value, because if you innovate and you create something and you're able to protect it with a patent, you can prevent others from doing what you have protected. Obviously, that can provide value in the marketplace, among other places. And so we kind of already touched on this, but that invention, it is for a limited amount of time. This is not forever. In the United States, it's 20 years for a utility application, 14 years for design application. There's also plant patents. And you get that exclusivity in exchange for public disclosure of your invention. So when you want to and make the decision to file a patent application, that patent application, not the actual issued patent itself, that patent application will ultimately publish. And that publication is part of the underlying foundation and structure of the law that in exchange for that exclusivity, if you're ultimately granted a patent, you've essentially disclosed and enabled others to make and use the invention. So there's a little exchange there, right? You get exclusivity for basically disclosing the invention. So Congress, actually patents, they go all the way back to the Constitution, Article 1, Section 8. A little known fact, but that's where you can find the basis for the patent system in the United States. This is the really lawyer stuff that I probably won't burden you with. 35 USC 37 CFR, and then this document called the MPEP. If you're interested in really diving into the laws, rules, regulations associated with patents, that's where you'll find all of that information. I'm going to breeze over that. So how do you get a patent, right? Well, you have to file a patent application, and you file it with the U.S. Patent and Trademark Office. Their headquarters are in Alexandria, Virginia. They do have satellite offices throughout the United States. 8,400 patent examiners. These are the individuals who examine your application. You, as counsel, you work with them to hopefully get that application granted. You can see these numbers are from 2021, so they're a little bit dated. These inch up typically every year, but you can see that the volume that's being handled by the Patent and Trademark Office, it's indicative of the innovation that's going on in the United States. So, you can't patent everything, but you can patent a lot of things. So you can patent any new useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof. So that language right there needs to be unpacked just a little bit, but it's easier done from the inverse, looking at it from the opposite side. So what can't you patent? Can't patent a law of nature, physical phenomena, and abstract ideas. So abstract ideas, it's a hot area in patent law right now. And if you're working in artificial intelligence, machine learning, right? Those are very hot technological areas. Sometimes those types of technologies trigger rejections from the Patent and Trademark Office for being what they consider to be abstract ideas. Now there's ways around that, but that's an example of a type of technology that might implicate some of these types of technologies that cannot be patented. Don't take that to mean that AI and ML type technologies cannot be patented. They absolutely can. You just have to be a little bit careful with respect to how you prepare an application, the types of information that you provide in that application, and how you claim the ultimate invention. So, wanted to start off here and talk a little bit about the patent process. So sometimes there's misconceptions that you file a patent application and that's it. You get a patent. That's unfortunately far from the truth. The process takes quite a while. There's different types of applications that you can file. This is just, I think, a general timeline that you might expect. You might start by filing a provisional application. We'll talk a little bit about what that is. You then move within 12 months to file a non-provisional. 6 months after that, your application would publish. That is not granted as a patent. It is simply a publication of the application. And then typically, within 2 years of your non-provisional filing, you would hope to see a first office action. And the office action is essentially the analysis of the patent examiner at the Patent and Trademark Office. Typically, they'll reject you, unfortunately. Well, then we work with them to identify what subject matter might in fact be patentable. And then you go back and forth a little bit, and hopefully you get a patent. Don't let me convince you that every time you file an application you will always get a patent. That's not true. It differs per technology areas. There are real risks with filing a patent application. There's the risk that you may never get a patent on that technology. So there's certainly risks involved, but again, if you don't try, you don't know. So that's a little bit of a timeline, and as you saw, it drug out to 5 years. That's fairly long. So within that 5 years, lots can happen, and you would kick off that patent filing process oftentimes by filing a provisional application. And this is an application that's very useful for establishing a date and time for priority purposes, for what qualifies as prior art. And that's ultimately impactful for what the examiner can utilize against you should you choose to proceed with a non-provisional application. You recall that we had, within 12 months, you'd file that non-provisional after the provisional filing. Interesting differences between these two. The provisional does not get published, okay? It is held in confidence at the Patent and Trademark Office. It will ultimately publish if you file a non-provisional application and it subsequently grants. It'll be included in the file history, but the non-provisional application is the one that actually goes through examination at the Patent and Trademark Office. So you'll see here 2 documents that look similar but different, right? The one on your left is a patent application publication. And this is useful to understand what is a publication versus a patent. A publication is just that. There's not an exclusivity right associated with an application publication. It is merely a publication disclosing that technology. Now, the one on your right, that is an issued U.S. patent. You can see here that it says pub number, that's the publication number, and here you see patent number. So that's one difference. This is actually the exact same application, even though the drawings look different. You can see here that we have a provisional application that was filed, and this has to do with priority claims. Understanding how to read these types of documents can sometimes be helpful in understanding what types of information might be relevant to your specific education and understanding of the art, in addition to many of the probably academic publications and journal articles that you're very familiar with already. So again, I know you're going to see this timeline a couple more times, and the reason for that is it's unfortunately a slow process. There are ways to speed it up. Unfortunately, they're very expensive. You have to pay special fees to the Patent and Trademark Office, so most of the time, folks don't do that. So if you think, hey, we're going to file it and we're going to get something issued within a year, that's probably not going to happen. So unfortunately, patience is the name of the game in patent preparation and prosecution, but just wanted folks to understand that the process is long and involved, but at the end of the day, it's possible to get a patent. So if you create intellectual property, if you think you have an invention, you disclose it to the university, the tech transfer office of the university. We'll touch on that later. And I know that some of you have been through this process, but once you prepare your disclosure documentation, you'd submit that to the tech transfer office of the university, and they would engage outside counsel, somebody like myself or other patent attorneys, and then we come and interview you. We understand your technology, and we ask you a bunch of questions about it so that we can prepare a patent application based upon your technology. So there's going to be a specification. Think of it as the detailed description. That's where all of the technological details about your invention will be. There will also be drawings, right? Drawings, maybe it's a method, maybe it's an apparatus, it's a process. The drawings will help to further illustrate your invention. Then there will also be claims, and claims are the interesting part of an application. That defines the scope of the protection that you are seeking. There's also some additional formal requirements associated with this. Execution of oaths and declarations, and if you're an inventor, you have to sign all of these things. An oath or a deck, and the assignment. Those two things would come back to you as an inventor for your execution. And that would all be handled through either your outside counsel or the tech transfer office. So let's say everything goes well and you get an issued patent. That's great. You file the patent, and then what happens, right? So there's the process of preparing it, working with you, the inventor, to put the application together, and then it gets filed. Well, what happens then? So you can see here a bunch of different potential things that could happen. There'll be office actions, right? We had mentioned that examiners may reject you, and then your attorneys would advocate on your behalf to get the patent. One important thing that inventors, I think, need to be aware of is the patent laws require that an inventor of a technology, if they're aware of any material prior art references, they must disclose that to the Patent and Trademark Office. Your attorneys are ethically obligated to do the same thing. So is the university, but it also includes inventors. So you would typically understand all of the closest references, right, or the ones you were aware of. There's no obligation to go find the best prior art. But of the ones that you were aware, you would need to let the tech transfer office know or your outside counsel know so that they could disclose that information to the Patent and Trademark Office. That's an important aspect, and if you go through that process, you'll certainly be asked about that. This is typically what the process looks like. We've touched on this briefly to date with the timeline, but you can see above the line here, this is typically up until issuance. This line is you get a notice of allowance, right? This is a great thing. The Patent and Trademark Office has decided that your technology is patentable, and they've decided to allow your application to grant as a patent. And oftentimes, you'll have the opportunity to file what are called either a continuation or a divisional application. And it's the same specification and drawings, so it's the same disclosure, but we claim different things. So you may have in your application described a process, right? A process for making a certain material. Well, you might claim the process, and you might be lucky enough to get that patented, but you also want to claim the material, or the material that was made by that process. And so these types of continuing applications or divisional applications enable you to do that. So after your patent issues, there's some technical things that have to happen. You have to pay to keep it in force. And so the university does that, and those fees are utilized by the Patent and Trademark Office to fund their operation. That's neither here nor there, but I did put marketing, licensing, and commercialization under post-issuance activities. And the reason for that is these things can happen prior to granting of a patent, but they become, I guess, a bit more scrutinized typically post-issuance when these fees start to be, and these maintenance fees start to be incurred. And so efforts to market the technology, to license the technology, to find commercialization partners, once you have an issued patent, you can think of it as it probably ratchets up a little bit. The opportunity there to license is very evident with an issued patent. And so finding those commercialization partners is something that becomes a bit more prudent after, once you've already got an issued patent. So we're going to talk briefly about foreign filing, and I'm kind of laying the foundation here to get to what I consider to be institutional considerations that are going to be specific to the University of Wyoming and the research setting. So I had mentioned earlier that there's no such thing as a global patent, right? If you want to patent your technology in the United States, you need to file a patent application in the United States. If you want to patent it in Germany, you've got to file a patent application and prosecute it to issuance in Germany, just like you do every other country. There are some, in Europe, there's a mechanism by which you can prosecute it once at the European Patent Office, but you still have to perfect that filing in every single country that you want to ultimately have patent protection in. So foreign patent offices don't operate necessarily under the same rules as the United States Patent and Trademark Office. As you can see, there's many different patent offices worldwide, and this becomes important when we get to institutional considerations with respect to publication. Obviously, in a university setting, publication is a very, very important aspect of whether you may be a PhD student, you may be a researcher, you may be a faculty member. Publication is certainly a very important aspect of what you do on a daily basis, right? Dissemination of the technology that you've created, your learnings, right? Your contribution to the public knowledge, right? Well, unfortunately, publication and patenting don't always play well together. And what I mean by that is if you publish something or you publicly disclose your technology, let's say you come up with a great new technology, and you publish a journal article on it. It's accepted, let's say, by the journal Nature, and it's published. And that's huge, that's exciting, right? Well, if you do that, and you don't have a patent application on file, you essentially foreclosed your opportunity to file a patent application on that technology anywhere outside of the United States. The laws are set up with respect to novelty to discourage public disclosure of your technology until you file a patent application. So that's why sequence matters. You can always publish, but a best practice would be to have a patent application on file prior to that publishing or public disclosure. And so they're not mutually exclusive. They can work together. Your publication doesn't have to be necessarily slowed down by a patent filing. That can be done reasonably quickly with a provisional application. I will say that in the United States, you do have a 1-year grace period. So if you do, in fact, disclose your technology publicly, the United States gives you a 1-year grace period where they'll still allow you to file a patent application on that technology and not have your prior public disclosure qualify as prior art. Essentially what it would do in other countries, you would be your own prior art, and therefore you would prevent yourself from getting a patent. So that's how impactful a public disclosure can be. And so I want to talk about the specific types of public disclosures that can be burdensome or can trip folks up when we're talking about, hey, we would like to build and protect the intellectual property of the university, but in your day-to-day lives and careers, these things come up, and sometimes we don't always think, well, what are we doing about the intellectual property? So printed publications are a type of public disclosure that can destroy novelty and thus potentially prevent obtaining a patent on that technology. So we've listed several different types of public disclosures, specifically printed publications. Not only journal articles, I think that's maybe the best example, the most common example, but a conference presentation. If you attend a conference and you're a presenter and you have a slide deck just like this, that can be a public disclosure. A poster presentation at a conference, a catalog thesis or dissertation defense. We've over the years come across a litany of publicly accessible databases where folks sometimes decide that they want to upload their white paper prior to any peer review. Well, if it's publicly accessible and I can find it via Google, that's going to qualify as a printed publication, and that can ultimately destroy novelty. There's other types of public disclosures on sale or in public use. So if you happen to sell the technology, that qualifies as a public disclosure of that technology. It's not like you went and told anyone about it, but if you sold that technology, that could qualify as a novelty destroying public disclosure. And then there's a catch-all provision of the laws which says, or anything otherwise available to the public. And so simply talking to someone about your technology without an obligation of confidentiality in place could potentially be novelty destroying and ultimately negatively impact the probability of obtaining a patent on that technology. Now there's strategies to prevent that, and the most effective strategy is don't say anything until you file a patent application on it. That's the best practice. Now I understand in real life that doesn't always happen, or the timing doesn't always line up, or you've got somebody coming in tomorrow to see your lab, and well, what do? We're going to show them our new technology, right? Well, we don't have maybe time to file a patent application or gather the materials. So what do, right? Well, when we collaborate with third parties, or think public also there, or others, you can always use a non-disclosure agreement. A non-disclosure agreement is a very effective tool that addresses the idea that folks coming to work with you or collaborate with you will likely see information, proprietary information, that needs to remain confidential. It is very, very important to have those NDAs, non-disclosure agreements, in place prior to meeting with third parties. Those can be very, very helpful in establishing evidence that your meeting with a third party, does not qualify as a public disclosure. There's other types of agreements or arrangements, right? IIAs, interinstitutional agreements, sponsored research, where there may be collaboration amongst parties outside of the university. And those types of agreements are handled by the University Tech Transfer Office. And so they can help you with that. But many of those agreements, all three of those, will almost always implicate and have provisions in them that concern proprietary information and the rights associated therewith. I did want to highlight here the intellectual property regulation here at UW. This is University Regulation 9.1. I'm going to start with the last one because I think it's the last, bullet down here. So this is just per Regulation 9.1. Essentially, any invention made at the university, you must disclose that to the university. Now, the university will then do the analysis and determine whether or not to file a patent application on that technology. If that decision is made to pursue a patent, right, UW will cover the cost of that patent. That can be fairly expensive, and so that's kind of nice. UW manages the portfolio and collaborates with their outside counsel. And then if you're an inventor, you receive what is assuming after recovery of costs, if your technology is ultimately licensed and generates revenue, the revenue sharing provision per the regulation directs 60% of that income after cost recovery back to the inventor. So that's available online if you want to look more into that. But I thought that was relevant from an understanding standpoint to understand the IP regulation here at UW. So the Technology Transfer Office, you've heard me mention that office several times. I don't know if any of you have had previous interactions with that office. We're fortunate to have, I think, some folks in the room who have experience previously in that office. I'm going to mention Tiffany Bishop here. She's at the School of Energy Resources, but was formerly at the Tech Transfer Office, and she's a great resource that can provide you a lot of information about the types of information that the Tech Transfer Office will look to collect if you have an NDA that needs review, or if you have an invention disclosure, or any of those types of issues. She'd be a great resource. So these are the types of services that the Tech Transfer Office manages. IP management, right? For the entire university, they handle the university's patent portfolio. Again, they work with the IP protection strategy, right? Whether or not to file, how to prosecute all the IP to issuance. They work and support commercialization of the technology. They also handle copyright filings. Copyright filings typically won't be relevant for processes or materials or anything of that nature, but if you create an artistic work, and that can include software. So if you write software, software is typically considered to be copyrightable. If you create a graphical user interface, sometimes that can be copyrightable. If you write a book chapter, that's copyrightable. That's kind of so they can help you with that as well. In addition, several of those agreements that I had previously mentioned in NDA, don't know if you are familiar with material transfer agreements. I'm sure some of you probably are. That office also handles those. Interinstitutional agreements. Again, we talked about that when we were discussing collaboration with third parties. It's always beneficial to have an interinstitutional agreement when you're working or collaborating with others at another institution. Those agreements will typically delineate IP ownership, cost share, and a myriad of different provisions, but they can be messy to do once you've already started collaborating. You know, it's like trying to put the egg back into the shell after you've broken it into the pan. Sometimes it's a bit messy. Data transfer use agreements. Also licensing. So one goal of the university is obviously to disseminate the technology that has been developed here, and a frequent methodology by which they accomplish that is through licensing of that technology to third parties. So to commercialization partners, they'll seek, if they think they have a technology or a space that they could implement a UW technology, the university will certainly consider licensing that technology to them in exchange for royalties on the back end, typically. So again, those are all the types of services that the Tech Transfer Office handles. This one got its own slide because this is one of the most important forms you will see if you are a UW inventor. And I cannot stress enough that this document, and I should have probably included a link to it, or I should have printed out 100 of them. This document is very, very important. If you have an invention, you need to download this document. It's at the Technology Transfer website. And it's not only going to ask you some of this basic information, right, about describe your technology, the title. It's got a lot of other elements. It's about a 5 or 6 page document that collects a bunch of very, very important bibliographic information, whether or not there's any federal funding used. It collects information on the disclosure status. Has this been publicly disclosed? Has it not? Who are the inventors, contributors? It has sections for all of that information, which all becomes very, very important for record keeping in the patent in the Tech Transfer Office, and ultimately for making decisions on the best way to file a patent on your technology. So, if you see this sheet, understand that it's a very important one. If you have an invention, make sure you use the one that says UW inventors. If you're obviously a UW inventor, there's another one for non-UW folks. But so these are the folks in the Technology Transfer Office. If you had an invention, you'd want to reach out to this gentleman, Andy Applegate. He's the Tech Transfer Manager. Josh Brackett handles licensing. You can also reach out to him. This email is monitored by both of those individuals, and so you could submit your invention disclosure there if you have any general questions. Typically, they're pretty good at getting back to you. Located over at the WTBC off of Harney, in case you want to drop by and pay them a visit in person. And currently, the director, the former director of the Tech Transfer Office, left to take another position, and so the university is undertaking a search to find a new director and staff up the office a bit more robustly to better serve the university, the faculty, and the researchers. So I want to make sure I leave enough time at the end for questions, but wanted to touch briefly on careers in intellectual property. And so I'm going to focus today primarily on the patent side of things. And so, you know, obviously I'm a lawyer. If you're a glutton for punishment and you're a student and you're thinking, I want to go do this, you know, we can chat. But if you want to be a patent attorney, for example, you might do different things, right? So what does a day in the life look like, and what types of things would you maybe do? So you would work with clients to prepare and file patent applications. So our firm works with many UW inventors here to understand the technology, draft these patent applications, some of which can be, you know, 50, 100 pages long, right? Very, very data heavy, very, very technically dense documents. And those patent applications not only have to serve as an enabling technical document, but also a legal document. The audience is also multiple. You've got a patent examiner who has to be able to understand the technology. You also advocate for that examiner to understand the technology well enough to understand that there isn't any prior art that would prevent getting a patent on that technology. But another audience might also be a jury, right? If you're able to get a patent and you enforce your patent, right, that may be tried in front of a jury. And so you can imagine that a 100-page patent document that's littered with, you know, very NMR resonance data might not be accessible to your average jury member, right? And so what you have to do is you have to be able to create this document that not only satisfies the technical qualifications, but also presents it in a manner that is ultimately accessible to maybe someone who doesn't have your level of or expertise in that specific type of technology. Patent prosecution is another thing that a patent attorney might do. You go back and forth with the Patent and Trademark Office to ultimately obtain patents for your clients. You can assist in patent licensing, portfolio management and diligence. That can mean a whole bunch of different things, but opinion work. So opinions might be provided if a client came to you and asked, well, we received a cease and desist letter, okay? That's not good, right? Some company has alleged that we are infringing their technology. Well, what you might do is you might assist your client, and they may say, boy, we don't think we are, but we need to know. And so you might prepare an opinion, a non-infringement opinion, or an invalidity opinion, saying that that individual's patent or that company's patent that they're alleging that you infringe, in fact, isn't even valid in the first place. So those are types of activities that you might undertake on a daily basis as a patent attorney. And then all of those things from here on up, you can consider these to be more transactional in nature. The transactional side of IP is significantly different from patent litigation. Patent litigation is probably what you think of when you think of a lawyer in the courtroom. And quite honestly, maybe only 5% of a litigation is actually in the courtroom. A lot of it is spent buried underneath boxes of documents. But litigation is very different from the transactional side of things. But ultimately, that would either play out as either helping to enforce a patent against an infringer or defend against an allegation of infringement. Now, there's also trademarks and copyrights. Those are other types of IP. I should throw trade secrets in there too. But trademarks and copyrights are a little bit different from patents, right? Trademarks, I'm sure you all are all familiar with trademarks. I've seen many of them throughout the room. The steamboat is a trademarked element, right? Everybody knows if they see the steamboat or they see brown and gold, what do they think? University of Wyoming, right? State of Wyoming. And so trademarks are a pretty interesting area of the law with respect to branding. Also, copyright work is another type of work that you might do as an intellectual property attorney. I do note that to do trademark and copyright work, you don't need to be a registered patent attorney. So these are kind of the different levels of and different opportunities that you might have to pursue a career in not just IP, but specifically patent. So to be a patent attorney, you've got to go get a bachelor's in a hard science or in engineering. When I say hard science, not political science. So all of your engineerings, your biology, chemistry, physics, computer science, all your engineerings, at least an undergraduate bachelor's. Master's, PhD is also great. You got to go to law school, and then you've got to pass the state bar to be a lawyer, but you've also got to pass what's called the patent bar. And the patent bar is a federal bar exam that is put on by the Patent and Trademark Office. In order to sit for that bar exam, you have to prove you have the requisite qualifications from a technical standpoint. And the easiest way to meet that is having at least a bachelor's in a science or an engineering degree. There are other ways that it can be met, but for the students here, since you're probably either have a bachelor's in science already or are getting one, that's the easiest way to qualify to sit for that bar exam. You can still practice patent law as a patent agent, and this is a really unique, to intellectual property and specifically patents. So you can actually represent clients as a patent agent without being a lawyer. Now, typically, as a patent agent, you need, again, an undergrad science or engineering degree at least. Many patent agents will have master's or PhDs as well. And you need to pass the patent bar. You do not need to go to law school. We have maybe a dozen or so patent agents that work at our firm. They practice under our law licenses for malpractice and insurance purposes primarily. But they are qualified to represent clients before the Patent and Trademark Office. So that's another option. A third option is actually what we call, sometimes they're called patent engineers or technical advisors. These are folks who have either a bachelor's or master's or PhD in a science or engineering degree, and you haven't passed the patent bar yet, or you don't want to, but you still want to work in intellectual property. You can, and we have, again, multiple technical advisors at the firm that assist the patent agents and patent attorneys in preparing and filing patent applications, because you can leverage that technical expertise that you have into that type of position. Now, to do trademark and copyright work, I already mentioned science and engineering background is not required to practice those things. It is for patent law. So just a nice distinction there with respect to different opportunities in intellectual property. So, wanted to leave some time for questions. I think I did that effectively, but yeah, right on time, 12:45. Perfect. So, wanted to thank the School of Energy Resources again for the opportunity to come and present to y'all. Thank y'all for giving me 45 minutes to an hour of your time to listen to a lawyer drone on about highly technical IP stuff. Also wanted to thank Christine Reed and Tiffany Bishop here at the School of Energy Resources for putting together today's event. So, without further ado, if anyone has any questions, obviously willing to take any questions. And Richard.
That's a very enlightening presentation. I learned things I didn't know, and I've been working in this area for years. So thank you for that.
Certainly.
First of all, I was staggered by the number of people who were manning up the patent office. Could you say something about how that process works? Does the patent go in to one person who makes the judgment and gets back to you? And my second question is, you've gone through the filing process. What is the patent officer or the patent office looking for to say, hey, I will award you a patent?
Mm-hmm. Yeah, great question. So Richard's first question there was, and correct me if I get this wrong, just so everybody can hear it. How many? I already forgot. I'll answer the second question, is what are they looking to allow for a patent? So technically, so long as there is no prior art, right? You claim whatever your invention is, right? And you present that to them, and they will go and search the prior art, right? That is, in theory, every publicly available description or disclosure of related material technology typically included in previously filed patents and patent applications and journal articles or other publicly available materials. So ultimately, at the end of the day, you need to convince the examiner that what you are claiming is either is not only novel, in other words, it's never been done before, but it's also non-obvious. Those two, along with some other some other qualifications, but that typically don't come up. Those two things are the most, typically in practice, the most important things that you need to convince the examiner to get it issued. So novelty is actually, can be surprisingly easy to prove. Obviousness is difficult to overcome. If an examiner alleges that your invention is obvious, that's a more difficult proposition typically to overcome. There's ways that you can redefine what you're trying to claim to overcome that. You can submit declarations of experts, basically countering the examiner's position. There's numerous different ways to attack an obviousness rejection, but the best way I can describe an obviousness rejection is not you know it when you see it, but let's say, for example, that you came up with a serrated knife with 9 serrated edges, okay? And let's say, again for this example, it's not the best example, but that never before had a serrated knife with 9 serrated edges ever been made, created, disclosed. It's brand new, right? Never been done before. It's totally novel, right? Well, let's say that the prior art or what had come before, right? Let's say that there was a serrated knife with 7 serrated edges, but not 9, right? And there was maybe another publication that talked about cutting efficiency of serrated edges. And it led to a conclusion that, 2 serrated edges are good, but 3 is better, and maybe 4 is even better than that. Well, if you took both of those references together, right, a knife with 7 serrated edges and a publication or a reference that suggested more serrated edges are better to improve cutting performance, well, that would likely obviate a knife with 9 serrated edges, even though a knife with 9 serrated edges had never been created before. Now you have to set up the application. Typically, what you'll see is a kind of problem-solution approach. Oftentimes you'll create a narrative in the document to convince the examiner of a currently existing problem, how your invention and technology addresses that problem, and how it overcomes it, and the ultimate benefits associated with your technology. So that was one of your questions, and what was your other question? Because I forgot.
I asked it, there's a lot of people in that patent office, so when you submit your patent, does it just go into the guy's office who makes the
Yes.
decisions? Or do they work as a team? I mean, how does it I'm just curious.
Yeah. So Richard's question was, when you file a patent application, does one examiner look at it, or does a team of folks look at it? How does that application work its way through the patent office? So what it's done is it's actually, they're called art groups. So for example, let's say we file a technology on some sort of technology to do with coal, okay? Well, they're not going to put that application in the computer science art unit, right? Because the computer science art unit is staffed with folks who have computer science degrees and backgrounds. They're going to put patent examiners with geology degrees, maybe petroleum engineering degrees, maybe geophysics degrees in the art unit where a coal technology would likely ultimately land. And so when that happens, then it is a bit random which examiner gets assigned that new technology. And then typically it is one examiner that you work with. Now it's possible to go beyond that. You can ultimately, if they continue to reject you, you can appeal. You can request pre-appeal brief conferences with multiple examiners. You can ultimately appeal all the way to the Patent Trial and Appeal Board, which brings in typically 3 administrative law judges who are not examiners, typically. And then they can adjudicate a potential outcome different than the position the examiner's been taking. But it's very important to create relationships with those examiners. We often will, it's not required, but often for every case that I handle, I will call the examiner every office action I get. Not only to create a relationship, but also to take the opportunity to educate them on the technology. Because I often find that they don't have necessarily a full grasp on the technology, and sometimes if we can clarify for the examiner what we are specifically claiming and really kind of, oh hey, they might have missed something, oftentimes we can get them to understand the differences between what we believe to be inventive and what they've cited against us as prior art in their rejections. So, other questions, concerns? Oh geez, that's a lot. Let's start in the back there.
Someone who has a new idea or technology that is useful, when they want to patent, they don't get any reward or support, and instead they should pay money for patent.
Yeah, so I mean, assuming you're asking about the cost associated with patenting. Boy, that's a tough question. That question, it can range. So a good answer there is it is not cheap. It is objectively not cheap. Typically, what we would see for a patent application, not a provisional necessarily, but a full-blown non-provisional application, it depends on the type of technology that's being disclosed. It depends on the type of information. It depends on the level of expertise necessary to prepare that application. But typically, you'd see just the application preparation cost is likely going to be upwards of $10,000. In addition to filing fees, the costs associated with patents from filing to issuance is typically going to be in the realm, again, it depends, every case is different, but in the realm of $20,000 to $30,000. So it's unfortunately it's an expensive proposition. There are ways to reduce cost. Getting much lower than that is a little tough. There's also that's a tough question to answer, to be quite honest. But the university, for UW inventions, it is not the inventor's responsibility to fund the filing and the filing fees, the patent fees, and then your counsel fees. The university handles that. So, did I answer your question? I hope I didn't sidestep it.
Yeah, I think, but I'm surprised that why a person who has a new idea that is useful for society, instead of getting the support or reward, should pay.
Yeah. So, talk to the tech transfer office. They can probably provide you some more guidance on that. Yes. Yeah.
So you mentioned abstract ideas, and you also talked about AI and type of inventions.
Mm-hmm.
So I assume, my understanding is it's very hard to get the patents in those fields, and that's basically my field, like software
Mhm.
side of it,
Yeah.
modeling and all. Can you maybe provide a few examples where one can actually get a patent?
Yeah.
Maybe cutting it off again, that would be
Yeah, absolutely. So any, and these are general rules, but you can definitely get patents in the AI and ML spaces. So don't take what I previously said is it's not possible. It absolutely is. I've gotten patents for clients for typically when those improvements improve computer performance of the computer. That's typically a very fruitful area. What becomes troublesome is when what you are coming up with or what the software is doing could in theory be replicated by a mental process. So for example, an algorithm, right? You could think through a problem, and if I do A, if it's A, then I do B, or C, if it's not C, I do D, right? If the software is doing the same thing that you could do as a mental process, sometimes the Patent and Trademark Office will say that that's not patent eligible because it's simply a mental process. Even though it's being embodied by software being run on a computer and the objectively can be done thousands, if not millions of times faster on a computer, right? I mean, we're talking big data here, right? You have a huge data set and you want to perform a bunch of calculations. In theory, is it possible that you could do those by hand if you had 10 years? Sure, right? But you can do them in 10 minutes, right, using your program that you wrote. There's clearly a benefit to that, right? But from a legal standpoint, that can be troublesome. That can still be considered to be an abstract idea because, you know, it's like a mathematical process or a mental process. So, I hope I answered your question.
Yes.
Yes, sir.
Is there a way of protecting an invention if an inventor dies or becomes mentally
There is.
incompetent before, because it's a long process?
Absolutely. Yep. There's absolutely, you can get powers of attorney. I've prosecuted cases where the surviving spouse, the estate even, the executor of an estate is the decision maker when it comes to execution documents, things of that nature. So there are provisions throughout the patent laws for that exact situation. Yes, sir.
I have a follow-up question with the lady here. So suppose that if a person has some invention, a method for doing something new,
Mm-hmm.
but he does not file patent, and someone else understands the method and he filed the patent, and can he stop the real inventor from using it?
Good question. So the question is, if you come up with a method and you don't patent it, but someone else comes up with the method or otherwise either learns it from you or comes up with it on their own, it actually impacts my answer. Can you stop them from patenting that? And the answer is maybe, but probably not. If they filed first, it's going to be very, very difficult to stop them unless you have very, very, very good documentation indicating that you had possession of the invention in its entirety. In enabling possession. What I mean by that is not just I had it in my head and I knew what it was, but you had written it down, someone had likely witnessed it and signed it, and you have documentary evidence proving that, and you could prove that they obtained it from you. Then you could probably stop them. But it's kind of considered a race to the patent office. It didn't used to be that way. The laws changed back in 2013. You used to be able to, if you could prove prior invention, even if you hadn't filed an application, you could have done that prior to March 16th of 2013. You can't do that anymore in most instances. So it's very important, if you have a technology, disclose it to the university, do the analysis, determine whether or not a patent should be filed, and then get it on file. Because there is advantage to having an application on file earlier as opposed to later. So.
My concern is I do not file patent, and maybe I do not have money to file, and I'm not interested in filing a patent. But can somebody file a patent and he stop me from using my method?
Absolutely. If they obtain the patent on that technology, yes.
Question on follow-up. If you sell the thing you make, does that then lock them? If you have sold 1 or 2 copies of this method, and now it's out in the open, everyone can use it.
So potentially, yes, it depends when they filed their application. If your sale, your public sale of that exact technology was more than 1 year prior, typically, to their filing, in theory, your prior sale would have been basically a novelty-destroying event that should prevent them from obtaining that patent. Now, whether or not the Patent and Trademark Office knows that during prosecution could be questionable. I mean, especially if it's not a huge commercial sale, if it's 1 or 2. I mean, was it only for research purposes? Was it truly a commercial arm's length transaction? All those variables would ultimately impact the analysis. So that's a tricky question.
Okay, well, I think we're out of time. But thank you so much for all your questions. He'll be around afterwards if you want to do any follow-up. But we want to thank you for coming.
Thank you so much.
And,
Appreciate it.
our next presentation will be at the end of February. So watch out for that one.
Thanks, everybody.
Thanks, everybody.